Hi everybody, welcome back. Me again, Eugene from CBES, Canadian Business and Enterprise Services. And in today's video about employment agreement, I'll show you how to structure employment agreement, how to do it right, which issues, topics and subjects to include in the agreement to make sure that your relations with the employees are as clear, predictable and future-proof as possible. So on a substantial side, go through the employment agreement and chapter by chapter create the definition of your relations with the employee, starting with the definition of the position. Of course, what position would be employee filling in your business? What are the expectations, KPIs, if you have such? If not, I suggest always make a reference to position description documents. That is something that will allow you in the future to make adjustments, improvements to a definition of employee's position, and if done in agreement with employee, this will be will become a part of your employment agreement for the future needs. In that context, define what are the reporting structure in your business. So who the employee will be reporting to, who the employee will be supervising. From that point, move into defining the financial relations, and that's not only the salary, but also the commissions, bonuses, benefits, health benefits that your workplace will be paying to an employee in a certain position. Make sure that you properly define what is paid regularly, like salary, like sales commissions, for example, health benefits, and what is not, like annual bonuses, performance bonuses, which is usually called discretionary bonuses. This will exclude them most probably from the calculation of employees' entitlements at the end of the employment relations. Move on and incorporate into your agreement your workplace policies, procedures, and rules, which is supposed to be in writing and will allow you in the future to adjust the relations not only with that particular employee but with all employees of the workplace, and set certain rules that will be enforceable through the employee's agreement. Of course, subject to compliance with certain conditions required by the law. Next, define special circumstances that your business will recognize, such as leaves of absence, whether personal emergencies, sick leave, family leave, and other types of leaves. Don't extend too much if you're providing only what is provided in the Employment Standards Act. It's already there in the law. You don't have to define it in the agreement. But if you want to provide more, such as 5 paid days instead of 2 or 10 paid days per year, you have to define it in the employment agreement. You have to define if the employee is entitled for the accrual from year to year, or those days expire at the end of each year. You have to define your right to request medical documents. That is not part of the act. Make sure that all these questions are covered in a proper way that will, in the future, protect your position if you request an employee to provide medical proof for the sick leave. Define vacation. Now, again, with vacation, if you do not provide anything in excess of the Employment Standards Act, which today means 2 weeks for the first 5 years and then 3 weeks thereafter, don't extend too much. But set rules how the vacation is taken. This is not part of the law. So scheduling, set certain timelines, time limits on when the employee can request to schedule a vacation. Define that this is the prerogative of the employer to decide whether to approve or not to approve the vacation to the employee. Move on into the termination of employment. How the employment is terminated, what are the conditions for the termination with cause, how it is done if it's without cause. It's very important to define what is your workplace particularly sees as those exceptional circumstances that will make the termination with cause, meaning not allowing employee to enjoy the rights upon termination, such as termination notice, severance pay, other compensations. Usually that should be limited to very exceptional circumstances, harmful to a business or intentional wrongdoing from the employee side. Some of those are defined in the law, others in common law, a decision of the courts. But it would be good to define it in writing in your agreement to make it as clear as possible. Now, when all these topics are covered, you must include certain additional issues, and the most important is define the application or non-application of alternative laws such as common law and equity acceptable in Canada and in Ontario to your employment relations. In many instances, when Employment Standards Act provide an employee with certain amounts of pay, let's say a week per year of severance pay, or a certain amount of weeks of termination notice, common law can significantly increase these entitlements, almost multiplying it by 3-4 times compared to the law. The beauty with the common law, you can exclude it from the application to your relations with your employees, but for that particular purpose you need a specific, explicit statement in the agreement that common law does not apply to those relations. One other important issue is define what the requirements of the workplace with regards to non-compete, non-disclosure, and non-solicitation of the employee towards the workplace. And while non-compete is generally non-enforceable in Ontario after the employment is over, it is very much enforceable when the employment is going on, and you can expect from your employees not to work for a competitor during the employment with your company. That connects to the issue of confidentiality of information that also should be covered by the agreement. But what is also very important is non-solicitation. And non-solicitation works in two directions. First of all, it defines that your employee, and in particular former employee, cannot steal or solicit your clients to other company or for the employee's personal interest, but also that the employee cannot solicit other employees and subcontractors of your company from terminating their relations with you and moving with the employee. These provisions are important, especially when the relations with the employee are terminated and there could be certain animosity between you and the employee. You want to make sure that your business interests are well protected. So after you covered those main substantial topics, and there are some other issues that of course should be included in the agreement, I wanted to pay a very special attention to the technical part. So first of all, make sure that the employment agreement, where possible, is signed before the employment starts. If it's being signed after, there is a legal problem with proving the enforceability of this agreement. I won't get into this today, but you have to keep it in mind. So if you come to an employee when they work even one day and you ask them to sign the agreement, make sure you consult a lawyer to make it right. Second of all, give the employee enough time to read the agreement and to get the consultation of a professional lawyer if the employee wants, to come to a proper agreement with the terms and conditions of the agreement. So technically, don't give the agreement in the morning, demanding it to be returned signed by the end of the work days. I usually advise my clients to provide the agreement at least 4 or 5 days before the date of signature. This way, employee will have the right, if they decide to, go and get the consultation from a professional lawyer. These are the basic technical aspects and substantial of the agreement. Of course, every single situation will require additional aspects, inputs into your employment agreement. I think that this is one of the most important documents in the operation of your business, and if done incorrectly, might result in huge losses to a business in the future, especially if employees that have been working for you for 5 and more years leave for certain reasons. The financial impacts on your business could be significant. So define them, consult a professional lawyer with regards to employment agreement, make sure it's properly drafted, but also avoid too much of a technical language. That we want our employees to be able to read the agreement, to understand what it says, and not to get lost in the professional terminology that is very strange and sometimes non-comprehensible for them. So this is the basic overview of the employment agreement. If you have any particular questions or certain topics that you would like me to cover more, please leave your questions or your comments in the comment section below. Subscribe to our channel to see our future videos. And if you have certain personal or specific questions relating to your business, please don't leave it in the general comment section. Go to our website, www.cbes.ca, contact us and send me an email. I will respond to you personally with a question, and if it will have some general application, I'll put it without the identifying information into the comment section. So thank you for being with us. Come back again. We'll provide more topics, more interesting subjects about making your business more efficient, better operating, protected, and how to do it overall right in Canada. Thank you for being with us.